Welcome to the Leaflet. As we dedicate this show exploring the foundations of our democracy through the lens of our guiding principle, Constitution First, let's embark on this engaging and enlightening journey with Advocate Nipun Saxena practicing at the Supreme Court. Nipun has penned 3 articles for the Leaflet, which are available on our website. Let us really try and attempt to summarize the complexities that the 3 new laws, the BNSS, the BSA, and the BNS bring to the table. Nipun, thank you so much for being on the show today.
Thank you so much for having me.
Nipun, let's start with why are these 3 new laws so important?
You see, the reason why these 3 new laws are so important is because for the very first time ever since 1860s, these laws are going to have a complete overhaul. They will govern every single incident of a citizen's life, from the inception of a case, say registration of an FIR, till the conclusion of trial. They will also deal with what you call substantive offenses. What is an offense, what is not an offense. They have removed certain category of offenses and they have brought out new categories of offenses. Right? They will also deal with evidentiary laws. What is admissible as an evidence, what is not admissible as an evidence. Can you place reliance on a certain category of evidences? So in that respect, they also deal with an evidentiary aspect, which is very critical to both lawyers, specifically in the criminal litigation front, as well as judges. So I think these 3 laws are very, very important because it will affect each and every citizen of this country.
Let me go on with this. Do you think that there was a need to overhaul these laws, the existing IPC, CrPC, and the Evidence Act? Was there a need to overhaul these?
I don't think there was any need to overhaul them because the system that has been in existence has worked out fine. Surely there are certain delays, and while these laws seem to cut those delays, as was the war cry when these laws were enacted. But once we delve deeper into each of these provisions, you will realize that instead of cutting down litigation, they are going to increase the litigation at least tenfold.
Wow, okay. Nipun, why are we particularly discussing the BNSS today?
The reason why we are discussing BNSS is because it will be replacing Code of Criminal Procedure. Now, procedure is something which is very, very intricate, but it is the most susceptible to a constitutional challenge. You see, nobody can challenge why a particular provision in substantive law was brought or why it was omitted, but everybody, and in fact, all eyes will be on the procedure, because procedural safeguards are a constitutional guarantee. Say, for instance, just to give you an example, you cannot tomorrow arrest a woman after sunset unless the police officers are women personnel, because if you were to remove that procedural safeguard, it will have a direct bearing on somebody's life and liberty, right? Therefore, these procedural rules become very, very important from a constitutional standpoint because there are certain guarantees. For instance, guarantee against handcuffing was something which was laid down in as long back as in D.K. Basu and Sunil Batra administration, right? In those judgments, the Supreme Court had said that handcuffing has to be resorted to in the rarest of rare cases and only for a specific category of offenses and a specific category of offender. However, these new laws will sort of create a constitutional infirmity in that sense. And when we go to them specifically to those provisions, then we'll discuss them in greater detail. But what I want to tell you is that every aspect of the birth of a case from a criminal standpoint, right from the point of registration of FIR till the completion of trial, appeals, revisions, bails, right, remissions, everything will be governed by procedure. And therefore, those procedural safeguards, which in over 160 years of our jurisprudence have evolved, would be severely impacted on account of these new laws.
Wow, so keeping this in mind, I think this is going to be quite the task for the two of us to, make this simple for people to understand the complexities that we're dealing with and try to shorten this, right? So maybe we can divide this show into 3 parts then.
That's right. That's right.
So in part 1, what do we want to discuss in part 1 then?
So in part 1, let's only talk about handcuffing. Let's talk about specific preliminary inquiry questions, and then we can take the rest in part 2 and part 3.
Nipun, coming to the most pressing question. The 3 new laws are going to come into effect from the 1st of July 24, right? What are the possible problems regarding the application of cases registered before 1st July and after 1st July 2024?
Well, I think you have hit the nail with this question, because the most difficulty which is going to come across is on the retrospective application. But let me give you a slight context to it. There are 2 sorts of laws. One is what you call substantive law, which is what creates, defines, and makes punishment of a specific offense, right? That's the substantive portion. Second is the procedural component of it, the one which we just talked about. While substantive laws can only be prospective, which is to say that if the BNS comes into force from 1st July, then any offense which is mentioned in the BNS will only come from 1st of July onwards, right? But the problem starts when you look at the jurisprudence that has evolved in specific context to Indian criminal laws, which says that procedural laws can also have retrospective application. Now, if they can have retrospective application, then you are in for a limbo, because for at least 20 to 30 years, conceivably speaking, you will have 2 parallel systems existing, one under the CrPC and another now under the BNSS. Now, that would mean that, say, just to give you an example, an offense is committed before 1st July, but the information is conveyed after 1st of July. So let's say the FIR is registered on 1st of July for an offense which was committed prior. But many provisions procedural provisions look at the date of registration of the offense as the important date. Say, for instance, questions with respect to default bail will kick in if you have made an arrest under the new procedural laws.
Right.
Now, let's say what happens to a scenario where a time limit of 90 days was supposed to come to an end sometime in July, which was registered under the previous CrPC. But since the question or the substantive offense happens to be a sexual offense, in which case under section 187(2) of the BNSS, you now have to complete sexual offense investigation within a period of 60 days. So now for the police, it's going to cause so much trouble, because now their deadline is shortened by 30 days. Whereas for the accused, it's going to create even more trouble, because now the accused, who was otherwise entitled to, say, default bail for failure of police to file charge sheet within the stipulated period from the date of arrest, whether the accused now gets bail or default bail after the conclusion of 60 days under the new law or 90 days under the old law, which is to apply, is something which is going to cause tremendous complication, both for the lawyers, for the judges, as well as for the litigants.
Let me just ask you this then. What were they thinking? I'm sorry, but this question is like, yes, I mean, I'm sure lawmakers here have studied the law and, given a lot of thought to this, but do you think there's no thought being given to the whole idea of bringing this up really fast? We'll talk about procedure.
No, that's a very good question.
But I want to understand the thinking.
You see,
why fix something that's not broken?
I think there's a problem at 2 levels. Let me give you a context to that problem. When the 2 claim of fame to these laws being enacted were, A, that they wanted to do away with the colonial legacy as if it were. And second was that it wanted to make processes simpler, expeditious, in order to carry out set timelines so that justice could be delivered. Both of them are very laudable objectives. But let's pierce the veil and find out whether they are in fact as laudable as it is being claimed. Number 1, are these laws colonial? I would say not at all. Because it is not the CrPC 1973 which was colonial, it was the Code of Criminal Procedure of 1894 which was colonial.
Right.
So when India gained independence, in 1961, there were close to 6 law commission reports which sat down from 1961 till 1973 to find out and to do away with those specific provisions which were a sordid reminder of our colonial heritage. So these 6 law commission reports dealt with every provision in greatest amount of detail for 13 years Indian parliamentarians, state legislatures, everybody sat down, mulled over it, and came out with the present law, which was CrPC 1973. So there was no colonial remnants, so to say. Right? Now let's go to the second part, deadlines, which were complete the investigation within a period of 60 days. Can you really complete an investigation in 60 days when you are harping on technological means? Today, all of us litigators who practice know that an FSL report, which is a forensic science examination report, takes forever to arrive. Now, if you were to add chemical laboratory tests to it, say for NDPS matters, if you were to add ballistic results, they would take their own sweet time to arrive. Does that mean you cannot file your charge sheet today? Usually people used to file supplementary charge sheets. Today you have also capped supplementary charge sheet.
Okay.
You cannot file n number of supplementary charge sheets. You have to take specific permission from the trial court. So are these provisions then, the timeline provisions, will they be held to be directory or will they be held to be mandatory? Because everywhere the word shall is used in the body of the new procedural laws. So I think it is not going to simplify things, rather it's going to complicate them till kingdom come.
Will there be any adverse effect on the pendency rate in the country due to these two parallel systems that are going to come into force now?
Absolutely. I think it's going to increase significantly the pendency rate which is already there. You see, on an average, a criminal trial's gestation period is usually between 5 to 10 years in a trial court, unless you are appealing revision, in which case it becomes 20 years or 30 years. Now, there are many judgments of the Supreme Court which says that an appeal is a continuation of a trial, which means that the appellate procedure will also be a continuation of the procedure which was employed during the trial stage, right? Which means that a CrPC procedure will go on for another 20 years time while the new regime is in force. It is going to create an obvious clash between having to sort of meander, as if it were, between the two procedures. And therefore, every accused is going to lay claim on the basis of the new procedure, which gives that person some sort of a respite, right? Say, for instance, in a cognizance case, which is a cognizance on a complaint case, an accused gets a right to be heard even before cognizance is taken, right? So every accused will want to rely on this beneficial incorporated in the new legislation to support them. And if that right is now denied to them, they will challenge it immediately, saying, sorry, you never heard me at this stage of taking cognizance. So then the judges will have to make a tough decision as to whether the old regime will apply or the new regime will apply. And this is going to significantly impair every trial in this country, because in every trial there is going to be an accused. And therefore every accused is going to make that complaint.
That just sounds very scary to
That's
me.
right.
That it is. Nipun, coming to the next question. In what major way has the system of registration of cases been affected in the new BNSS regime?
To answer your question, we have to travel back in time. Before 2014, you would have seen there was a system which was in place where the police officers often resorted to demanding bribes, or they acted under immense political influence to register or not to register a case, right? Suppose there is a person, an indigent, who comes to a police station and says, please register my FIR, there is a theft which has been committed. But the police officer, upon being influenced by extraneous considerations, often used to keep that person hanging in a lurch. So now the person used to write to the SP under 154(3). If the SP wouldn't have taken an action, he would have to file a 200 complaint or a 156(3) investigation request, or sometimes even approach constitutional courts under Article 226 or 482 to get something as simple as an FIR registered. You see, to cut through all of this, the Supreme Court, in its Constitution Bench decision of Lalita Kumari, clearly said that if the information discloses commission of a cognizable offense, the police has absolutely no discretion in the matter. They have to register an FIR. There was nothing called a preliminary inquiry if the information disclosed commission of a cognizable offense. The Supreme Court also said that upon failure or refusal or neglect of a police officer in registering the offense, action must be taken against the police officer. Right? Now, what happens under the new regime is that it carves out an exception to this fundamental principle laid down by the Supreme Court. It says for an offense for which the punishment prescribed is between 3 years to 7 years, the SHO of the police station will have the discretion to decide whether he wants to conduct a preliminary inquiry or to register an FIR. Now, just imagine this. A situation where a police officer has to sit and conduct a preliminary inquiry on a prima facie satisfaction. Now, prima facie satisfaction, the last time I checked and the last time we read laws, was the exclusive domain of the judiciary. It was the magistrate who, upon prima facie satisfaction, used to say that there are sufficient grounds for proceeding against an accused and therefore issue summons under section 205 of CrPC. Or a magistrate, upon perusal of the FIR, would have said that all right, it discloses commission, and therefore he would have initiated a warrants case or a summons case, whatever it is. How can you confer discretion on an SHO to decide for offenses ranging between 3 to 7 years whether an FIR is warranted or not? I think that's absolutely ridiculous, because it takes us back to pre-Lalita Kumari days. It will institutionalize corruption, it is going to institutionalize political clout, and it will make an SHO of a police station thana the sarve sarva, right, or the be all and end all of deciding whether to even initiate a criminal case.
So are you trying to tell me that if a woman gets attacked tomorrow, right, and she walks into a police station, it is up to the SHO to say whether he wants to file an FIR or register an FIR or not?
Let me take a step further and say, even if the woman is subjected to an acid attack for which the punishment is ranging between 3 to 7 years, she will be left to the mercy of a police officer to decide whether a preliminary inquiry is to be conducted or an FIR is to be registered.
My God.
And let's come back to that one particular objective, which was to cut short the delays. Now, what is left to the person? The person will then have to make an application again before the SP, go through the process all over again, which the Supreme Court had expressly taken judicial note of, namely file an application before SP, then go to the criminal court under 200, then go before the constitutional courts under 226, 482. You are going to compound litigation by leaps and bounds if you are to insist on this vice of preliminary inquiry.
In the same way, Nipun, let me ask you, for how many offences would there have to be a requirement of the preliminary inquiry to be carried out, and why is this provision problematic?
For almost 88 offences under the new act, requirement of preliminary inquiry is going to be there. That would include offences such as theft, criminal breach of trust, the newly incorporated refurbished sedition provision, the acid attack provisions, grievous hurts, you name it, and most of the offences will fall within the sweep of this preliminary inquiry.
Thank you so much. That was rather scary and enlightening, right? This is just part one that we're concluding right now. We have two more parts coming up, and Nipun will be in both the parts. Nipun, thanks so much for your time today. Looking forward to part two and part three.
Pleasure. Thank you.